Member Welty. Seconded by Member Oswald. Any discussion? Seeing no lights, all those in favor? Aye. Opposed? Passes 7-0. Now, on to Mr. Hassler. Thank you.
I have ballots for each of the officers.
Next on the agenda is the appointment of the executive clerk. I believe it's done by the chair. So I would appoint Mr. Hasker if you would accept that. Thank you. And
I would accept.
You accept?
I accept, yes.
And the appointment of the board secretary, Ms. Dolans, would you accept that?
Yes.
Thank you. That's not weird. And Ms. Steele?
Yes.
Thank you. Next, we move on to our multitude of resolutions. Member Wells, will you read the first resolution?
It's on the meeting dates.
On the meeting dates, yes.
Sometimes be green when you can talk instead of red. That's so counterintuitive. Mr. Chairman, resolved by the School Board of Independent School District number 709, St. Louis County, Minnesota, that the regular meetings of the school board shall be held the third Tuesday of each month at 6:30 at the historic Old Central High School, unless otherwise scheduled by the school board. Chair Kirby, I move Resolution B-1-17-3415 dated January 3rd, 2017.
Thank you. Do we have a second? Second by Member Harlow. Is there any discussion? Seeing no lights, all in favor of Resolution B-1-17-3415, say aye.
Aye. Aye.
Opposed? Then this resolution passes 7-0. Next resolution regarding designation of depositories and acceptance of collateral. Member Lefton, can't you read that, please?
I move B. Okay. Move B 1-17-3416. Resolution designation of depositories and acceptance of collateral. Resolved by the School Board of Independent School District 709, St. Louis County, Minnesota, and Duluth Teachers Credit Union, North Shore Bank of Commerce, BMO Harris Bank, U.S. Bank, KeyBank, Wells Fargo, Park State Bank, and Western Bank shall be depositories of the funds of this school district for up to a year period commencing January 1st, 2017, and said bank shall be required to deposit with said district collateral securities subject to approval by the school board and kept in trust. Resolved that the collateral securities pledged by the Duluth Teachers Credit Union and placed in trust at Federal Reserve Bank of Boston, North Shore Bank of Commerce, and placed in trust at U.S. Bank, N.A., K-Bank, and placed in trust at Federal Reserve Bank of Boston, all is provided by law and evidenced by trust agreements executed by the treasurer of the school board as officer of the depository bank and acknowledged by an officer of the bank holding the securities in trust shall be approved as followed. And then resolve that the treasurer, clerk, and CFO, executive director of business services shall be authorized to arrange for the exchange, release, or placing of additional collateral, provided that in all instances such exchange, releases, or placing of additional collateral shall be approved by the school board, and all new collateral shall be placed in trust with the respective aforementioned institutions.
Second.
Thank you. It's been moved and seconded to pass resolution B 117-3416. Is there any discussion? Seeing none, all in favor of resolution B 117-3416, say aye.
Aye.
Opposed?
Aye.
This resolution passes 7-0. Next, we move on to resolution designation of authority to perform electronic fund transfers. Member Sandsted, do you have that in front of you?
I do.
Could you read that, please?
Sure. Resolved by the school board of the Independent School District number 709, St. Louis County, Minnesota, that the CFO, Executive Director of Business Services, has the authority to designate a district employee to initiate electronic fund transfers as required by Minnesota Statute 471.38. I move resolution B 117-3417.
Second.
It's been moved and seconded to pass resolution B 117-3417. Any discussion? Seeing none, all in favor say aye.
Aye.
Opposed? It passes 7-0. Next resolution, B 117-3418, authorization for the superintendent of schools and the CFO to sign contracts and grants. Member Oswald.
Resolved by the School Board of Independent School District 709, St. Louis County, Minnesota, that to increase operational efficiency, it is requested that authorization to sign revenue contracts and expenditure contracts for the lease, purchase, and contract for goods or services within budgetary and policy limits up to $25,000 be granted to the Superintendent of Schools and CFO Executive Director of Business Services. This delegation of authorization is allowable under Minnesota Statute 123B.52 Subdivision 2. The superintendent's designee will review each contract before execution. Resolved that the School Board of Independent School District 709, St. Louis County, Minnesota, that the superintendent of schools, or in his/her absence, the CFO Executive Director of Business Services, be designated the legal authorized representative to sign applications and execute grant documents for and in behalf of the school district in connection with federal and state laws and funding authorities and local public and private funding agencies that offer categorical financial support to this district. Resolved by the School Board of ISD 709, St. Louis County, Minnesota, that a list of all the above contracts and grants hereby approved by the superintendent and the CFO or the CFO Executive Director of Business Services will be provided as an informational item at the first possible regular school board meeting following the approval action. I move resolution B-1-17-3418.
It's been moved and seconded to pass resolution B 117-3418. Is there any discussion? Seeing none, all in favor of this resolution say aye.
Aye.
Opposed? It passes 7-0. Next, resolution B 117-3419, selection of the district legal counsel. Member Harlan, can you read that?
I move resolution B-1-17-3419, resolved by the School Board of Independent School District 709, St. Louis County, Minnesota, that the following firms have been selected as legal counsel for the district. Listed as Frederick, Buchanan, Frederick, Travis, Dorsey, Newsom, Palmerville, Bradwick, Bozak, Maloney, Rob Anderson, Squires, Walsberger. Resolved that the authorized contact persons for the district are as follows. Chair of the School Board, Superintendent of Schools, Executive Assistant Superintendent, CFO, Executive Assistant, Director, Special Education Manager, Facilities, Finance Manager, Senior Human Resources Manager for non-certified staff, Human Resources Benefits Coordinator. I move resolution B-1-17-3419.
Wait a second.
Second.
Moved by Member Harlan and seconded by Member Lester Kemp. Is there any discussion? Member Johnson.
Thank you, Chair Kirby. I'd like to make a motion to amend this by Rozak and Maloney, and deleting Rupp, Anderson, Squires, and Wahlberg.
Second. It's been moved and seconded that the resolution be amended by deleting the two firms mentioned by Member Johnston. Is there any discussion on this?
I'm in support of all four firms, seeing that the two that are looking to be deleted by Member Johnston have a significant amount of experience working with educational institutions, and so understanding that a lot we brought up about past history they have helped us with when it comes to specific educational issues. So I'll be not in support of this amendment.
Thank you. Member Wilkie.
Yes, I spoke in favor of a similar amendment a year ago, and my particular objection is not so much with Rozak and Maloney, but with the second firm in this, Rupp, Anderson, Squires, and Waldsberger. And the objections that I have are all the same. I have had a strong sense that the Rupp firm in particular has played a very important behind-the-scenes, non-transparent political role in difficulties that this board has had. I note that Member Johnson has put in a number of requests, the other members of our board have, looking for legal advice as various legal issues have come up, and neither of these firms, which probably handle both kind of concerns that we have been made available to members of the board. I will say that I am aware from my previous experience on the board going back 20 years that the chairperson was the designated person to contact our attorneys, because of course they charge us for any consultation, and there was a great attempt to discourage other board members. But I have never, over a course of such time, had the sense that minority members were denied access to legal counsel, and that the legal counsel was not brought into closed meetings. And as I said, I think this all harks back to the political role that particularly the Rupp firm has had. I know that these two firms, originally was the Radwick firm in an earlier incarnation about 12 years ago, was brought in by Superintendent Paul Monson because he felt that a Twin Cities law firm would have deeper experience. But my experience with particularly the Rupp firm has been completely, totally unsatisfactory. I do not trust them, and I think it's a shame when members of the school board do not trust their own legal counsel. So I will vote for this amendment.
Thank you, Chair Kirby. I made this motion in hopes that the three new board members will chart a new course for this board. One way to do it is to eliminate the law firm which got us into the mess that we're into. Just a little bit, a very brief background. Kevin Rupp gave us extremely poor advice. It cost the school district close to $200,000 in legal fees. Most of it going to him and his firm, not all of it. Rather than telling the board that this was a losing proposition, he advised the board to continue with this. That was very poor advice. As soon as it went into court, it was immediately ended after $200,000. That is not good legal advice. That is extremely poor legal advice. We should be hiring lawyers who give us good legal advice, not to take personal vendettas by certain board members. And I'm asking the 3 new board members to vote with me to remove this firm. We have 2 good firms in Freiberger, Buchanan, and Driver, and they can handle our stuff. And there's other law firms that I think are more credible. And again, I think this is an opportunity for the board, 3 new board members, to set a new course for this board. I think we've been getting along somewhat better the last year. I think we have a long way to go. This is the time to move forward by getting rid of lawyers that got us into this mess.
Member Oswald?
I believe Nora, she's a great leader.
Member Sandstad?
Thanks. I'm wondering, it wasn't entirely clear if, sounded like Member Welty was suggesting that we amend the amendment to just removal of the last word, that perhaps just one is particularly offensive to certain members of the board. Can I get a clarification on that?
It was the last two, right?
And Member Welty voted yes.
I guess I'd like to know from someone, I understand what Member Johnson said about the rubber firm and not having confidence in them. What's the issue with Radway, is my question.
If I could answer the question, sort of was directed to me. I did not formally make a motion to amend. However, I would be quite happy to make an motion to amend because my principal objection, as I indicated, is with the Rupp firm. And on the off chance that limiting this to just one firm might make it more likely to pass and bring about some comedy on the board, I will do so now. I move to amend the amendment so that the only firm that we consider dropping is Rupp, Anderson, Squires, and Waldsburger, PA.
I'll second that.
All right, it's been moved and seconded that Mr. Johnston, Member Johnston's amendment to delete the 2 firms has been amended to delete only 1 firm. That's motion. And there's a second? By Member Sansky. Any discussion on this? Mr. Johnston?
Thank you, Chair Curry. Speaking against this amendment, and the reason why I think a lot of people don't know, Member Sanchez asked why I included them, and this is the reason why. They were hired by Rupp. They were part of it. They were part of the conferences down in Minneapolis. It was extremely nasty, and it was extremely expensive, thanks to the Radwick firm. And I'm asking this board to defeat this amendment because they are part and parcel of the difficulty. If we continue with them, it won't be the same as we have. So again, I'm asking the 3 new board members to vote no on this amendment.
Roswell?
Are we discussing the amendment to the motion? Okay. I support Member Welty's resolution to remove the Rupp firm, without any bias against them.
special education issues. We work with Amy Mace from that firm. She is one of the only special education attorneys that we know of, that we use all the time. I did want to point out just a correction that Radwick was assigned by the insurance company, not hired by Rupp on that, I believe. So we do have several current cases that we're working on them with.
Yes, several points. I understand the role of an attorney is to do what the client hires the attorney to do. And in the recently completed case involving our member, I do believe that the Ratwick firm was carrying out what the clients, we the school board, wanted them to do. I would note that I was about to make a correction. I hate to make a correction of my fellow board member, but I believe my fellow board member, Member Johnson, said that the Ratwick firm, or the A&F firm, encouraged the school board to go along with this. I remember quite precisely that whichever firm it was that explained the possible how this case might go on, told us that it would be ugly, it would last a long time, it could be expensive, and that there would be no guarantee. So we were warned that we were heading into treacherous territory, and that prediction turned true. My own guess is that that was just simply pro forma, what any attorney advises a client, so that the attorney cannot be accused of sugarcoating what is likely to happen. But not to put too fine a point on it, we were warned what we were about to walk into. In my experience, it has been Attorney Rupp who has caused problems. I would be willing to further amend the motion that we have to allow the Rupp firm to continue to represent us on any continuing litigation or affairs until such time as they were completed, at which point we would terminate the rest of our experiment, in fact, our work with them. I make that as a motion, if there would be a second, that we would continue the ongoing work that this firm is up to until such time as these particular cases are terminated.
I think you can only have 2 amendments at one time.
Well, I would offer that as a friendly amendment to my own amendment.
With person second. Is that alteration to it?
Member Sands, did you follow all of that?
I heard Member Welty. I couldn't hear what happened after the. Do you need me to approve the second of his amendment to his amendment?
Yes.
Okay, I will do that. Yep.
Okay. So the amendment now reads that, Member Welty, if you can correct me if I'm wrong, what did you repeated in the meeting?
Current amendment, the amendment.
With the friendly amendment added to it, or the change would be that we terminate our contract with the Rupp, Henderson, Squires, and Waldesberger PA firm, with the exception of ongoing cases that they are representing us in until the conclusion of those particular cases.
Member Sands, did you get that?
Yes.
Thank you. Member Johnson, is this?
Guess I'm not quite sure where we're at. I think that you have to go through and do it each one at a time.
Right, we're starting with the last one first, so it would be Member Welty's.
Okay, I think, I understand we have 3 amendments now, so that is okay.
No, 2 amendments. He amended his amendment, and Member Sands agreed to that. So it's that
Was his full amendment?
is full.
I think since Member Sandsted went along with my recommended change to my original amendment, we currently have an
Amendment to your motion, which does, as I said, would terminate our contract with the RUP firm with the exception of ongoing cases, and when they are conducted, we will terminate our relationship with that firm. That's the motion that stands now, which is an amendment to your amendment.
Is there a tech issue? What's going on?
Yes.
I want to look at that.
Okay.
This happens sometimes when we've been in the chair. Takes a little adjustment.
Hold the way. Yeah.
So, just to discuss that, I think the one thing that I've been hearing from the superintendent with regard to special education cases, I'm concerned that I know that there are other options in the sort of thing that there aren't. I don't want to leave us open for liability with regard to that, especially with the significance of what we receive from the case. So, I won't be supporting this, especially with the team. I understand folks are frustrated with the top of the bill and with history, but when it comes to staffing within their organization, especially with the needs, I want to make sure that we continue that relationship. I think that's important, that we don't leave ourselves open for liability.
Roswell.
I was also going to speak to that, hoping that if need be, we could offer an individual contract with that attorney for special education services rather than contracting with the whole organization, if that's even possible in the future, but I know that I don't think the spirit of the amendment was to retain the entire process as a possibility, but I understand that we do need for an individual attorney within the firm. So there must be a solution there somewhere, somehow.
Member Sandsted.
Yeah, I think that it's probably a limited area, and there probably aren't many other firms to replace it with. And I, for one, would like to have the opportunity to look at that and have it replaced in line before we cut off the real education experts in our list of legal counsel. So I don't know if this is something that we can deal with in the next couple of weeks or at the meeting in the January regular meeting, so that we can all do our homework on this. Otherwise, if not, I can't support cutting off the two firms from the Twin Cities that have more education experience than our local firms at this point.
You're welcome.
I appreciate Member Sandsted's willingness to second this. I can appreciate the concerns about special education. I, from long experience, know that special education is a very complicated law, and we need to have good attorneys representing us and advising us. I would like to have confirmation that Amy Mace is the only competent and capable special education attorney in the state of Minnesota, and considering we have hundreds of school districts with special interest needs, I find it hard to believe that Amy Mace is the only person that we can count upon. I have a question question before I proceed, and that would be if we voted to table this motion until our regular board meeting, is that too long to go without passage of this sort of a resolution so that we can get the information that we're discussing at the table today?
Superintendent Brown?
I was just reading the first Monday in January book, and it is not one that is bound by statute. It's just, it says it's a good time for the board to do this. So if you did not act on it, it would continue as it is currently until such time that you made a different decision.
In that case, we've got a couple of amendments, but I think it would be in order, a motion to table this entire issue until we have the research that we've requested to our conversation today.
Second.
2 seconds. Member Left Hand. Member Johnston.
Well, thank you, Chair Kirby. So I'm not sure where we're at here. I guess there's another motion on the floor to table. Is that correct?
Yes.
Speaking against tabling, I think it's time to make a decision. We can typically what we do when we hire law firms is we give that authority of the research to our CFO or our superintendent. We're not going to be doing that research. I've already done my research and I know where I stand on it. I think everybody else knows where they stand. So why are we kicking the can down the road? This is really silly. I think that it's time that we make a decision. And now I would have supported the amendment about keeping the rep firm on to finish out their business. We're legally bound with that. The obviously couldn't do that, so thank you for that amendment. So I wouldn't have supported that. I'm not going to support tabling. And I think this is
Member Justin, I completely agree with you about the desire to have counsel, legal counsel that I can trust. And I share your misgivings, particularly with regard to the rep firm. Because some questions have been raised that have allowed us to have, frankly, a good, candid conversation. I am willing to delay a decision, which apparently by law we don't have to make today, so that other people can be more comfortable with our desire to have counsel that we trust without damaging ongoing litigation or legal cases. And so I don't view this as a decision that has to be made today. In fact, I would regard a tabling or a delay as a good faith effort on the part of the majority, should we decide to do this, to heed our concerns where our legal counsel is concerned.
Thank you, Chair. I'm going to support tabling this because I am concerned about legal issues surrounding special education. There are norms that I don't want to make a hasty decision without knowing the ramifications of it. And I do think this deserves to be looked into further.
I've already said that I would have supported keeping the law firm on. They're the special, we're hiring one of their firm apparently for special ed. And I've already said that I support that because it's a legally bound thing. You can't terminate a contract. But again, candid discussion. When have we ever had a candid discussion on this board?
Member Sansted. table this. All right, move on to the next resolution. Member Johnston, will you read that section of the meeting?
Resolved by the School Board of Independent School District 709, St. Louis County, Minnesota, that the district's official newspaper will continue to be the Duluth News Tribune. I move resolution B 1173420.
Second.
It's been moved and seconded to resolution B 173420. Any discussion? Seeing none. All in favor of resolution B 1173420, say aye.
Aye.
Opposed? This passes 7-0. The next resolution, I think I will read to you a break. This is resolution B 1173421. Resolution accepting the 11 tools of civility. Whereas the residents of Duluth Public Schools ISD 709 place a high value on respect and civility in their lives, and they understand that these characteristics are essential to any healthy community. And whereas the School Board of Independent School District 709 supports opportunities for civil discourse and discussion in the community and within the school district. And whereas the School Board of Independent School District number 709 addresses sometimes controversial issues about which people often feel passionately and at which times lead to uncivil behavior. And whereas an atmosphere of incivility and disrespect can have a damaging effect on the proceedings, on the quality of debate, and on the practice of democracy itself, therefore, be it resolved that the School Board of Independent School District number 709 recognizes, says 11 tools of civility is encouraged by Speak Your Peace, the civility project that will provide increased opportunities for civil discourse in order to find positive resolutions to the issues that face our community. These tools include, number 1, pay attention. Number 2, listen. Number 3, be inclusive. Number 4, don't gossip. Number 5, show respect. Number 6, be agreeable. Number 7, apologize. Number 8, give constructive criticism. Number 9, take responsibility. Number 10, be honest and care for others. And number 11, show your evidence, share your reasoning. Be it further resolved that the School Board of Independent School District number 709 shall promote the use and adherence of these tools in conducting the business of the school board. I move the passage of resolution B 1173421.
Second.
Seconded by Member Harlow. Any discussion? Member Welty.
Yes, I think all of these 11 criteria are good and useful and scientific. But I do have a hypothetical question. I don't know who might answer it. But for instance, if a school board member was invited to a classroom to talk to students and was followed after the presentation by another school board member taking the teacher to task for inviting another school board member to speak to the class, would that be the kind of action that would be acceptable according to the resolution and the 11 tools of civility that we are considering right now?
I'd say absolutely not. I think if that hypothetical case I'm assuming, I think that person should be called on the table and censored. According to our rules of 11 rules of civility. That is violating number 4, don't gossip, 5, show respect, 7, apologize, 8, give constructive criticism, 9, take responsibility, 10, be honest and care for others, and 11, show your evidence and reasoning. It's pretty clear.
Member Saxton.
Yeah, I would just like to make a motion to correct the number here where it should say 11, it says 9 in paragraph 5, so that's consistent with the document, and then I call the question.
There's two things there. One is to change from wording from 9 to 11. Is there any
709 has included student school board representatives since January 2005, and whereas student school board representatives provide the school board with a student voice and youth perspective, whereas the Minnesota School Boards Association encourages school boards to develop a process to include student representatives, and whereas the superintendent and high school principals have reviewed and revised, where necessary, the selection process for appointing student school board representatives. Therefore, be it resolved that the School Board of Independent School District 709 approves the continued participation of one student school board representative each from Denfeld High School to East High School and the Area Learning Center. Be it further resolved that the term for the 2017 student school board representatives will be January 3rd, 2017 to January 2nd, 2018. Mr. Chairman, I move Resolution B-1-17-3422 dated January 3rd, 2017.
Second.
It's been moved and seconded to pass Resolution B-1-17-3422. Any discussion? Mr. Johnson.
Thank you, Chairperson. Just want to emphasize again, we had a real brief discussion on the last meeting, but I think it's important that the Area Learning Center representative is here. If necessary, I would suggest a school board member go and talk to one of their civic classes and talk about the importance of it and encourage them to select somebody to participate, because I think it's an important thing, and I would like to see their participation and somebody volunteer to go and talk to one of their classes to encourage such participation.
Thank you. Member Osborne.
Yes, I made the motion last year, and that was passed, that we had ALC representative, and I understand that ALCs have a hard time finding somebody interested in doing that. I believe that we should leave ALC on this resolution, so should any student want to participate, that they're able to, at whatever point they feel they're compelled to join. And I do agree that, recruitment may be necessary, and I think any number of us are more than happy to go speak and try to inspire some kids to come and give their voice to their high school.
I was just going to have Superintendent Drenson clarify what he brought up at the last board meeting about the student rep here and the process on that, so you could do that. So everyone's going off the same information.
Just that we had made another request for ALC rep, and the principal let us know that there wasn't currently anyone interested, and they respectfully declined.
Was that decline forever or just at time?
I think just at the time.
I think we have to continue to try and recruit some of that.
I believe one of the challenges was that most of the students aren't here full time. They're here for a portion of their day, and they're here for a while and then not here. So they kind of come and go, and I think that was the main issue of having someone here all the time.
All right, seeing no other lights, no other discussion, we'll vote on this resolution. All in favor of resolution B-117-3422, say aye.
Aye.
Aye, opposed? This passes 7-0. There are no other resolutions or items on the agenda unless there's something, Member Wells.
Yes, there's a small point of pique with me. I'm hoping that we can establish a slightly different protocol for the adjournment. And in the past, the chairs have looked around and not seeing any lights on, call the adjournment. That is really an appropriate thing to be asked of the board as a whole. And so I would appreciate if the chair would consider asking for a motion to adjourn the meeting so that the school board itself could vote on that and take on that responsibility of adjournment. Something for you to consider. You might want to try it today, for instance.
Unless Mr. Roberts says I can't. All right, before we do adjourn, however we do that, I would like to have you pass in your request for committees as Linda asked. And me.
And Nora.
I would like to thank everybody. I think we have a good year. Just remember that our objective is to improve the learning opportunities and outcomes for the students and the working conditions of the staff. That's our main objective, and I think we do that well. So can I have a motion to adjourn? So moved. It's been moved and seconded that we adjourn. Any discussion? None. All in favor of adjourning, say aye. Aye. Any opposed? We are adjourned.
Thank you.